Chair lays out on second reading Senate Bill 1056. The clerk will read the bill.
SB 1056 by Zaffarini, relating to the authority of physicians to delegate to certain pharmacists the implementation and modification of a patient's drug therapy.
Chair recognizes Representative Rainey to explain the bill.
Thank you, Mr. Speaker. Members, Senate Bill 1056 allows doctors to have a collaborative practice agreement with pharmacists in regard to patient drug therapy. Move passage.
Does any other member wish to speak on for or against Senate Bill 1056? If not, the question occurs on passage to third reading. Senate Bill 1056. All those in favor say aye. All those opposed say nay. The ayes have it. Senate Bill 1056 is passed to third reading. Chair lays out on second reading Senate Bill 1995. The clerk will read the bill.
SB 1995 by Birdwell, relating to the review of certain occupational licensing rules by the Office of the Governor.
The chair recognizes Representative Patty to explain the bill.
Thank you, Mr. Speaker. Members, Senate Bill 1995 seeks to solve an issue that looms large over Texas regulatory boards. The U.S. Supreme Court and the North Carolina Dental Board case created an exception to the law that states are immune from antitrust lawsuits when its boards undertake anti-competitive actions. Under the North Carolina case, for a state to continue to enjoy immunity from antitrust suits, the state must, 1, articulate a clear state policy to justify the anti-competitive action, and 2, provide active supervision of the agency undertaking the anti-competitive action. Senate Bill 1995 would create a division in the Office of the Governor to undertake this active control of anti-competitive actions.
Mr. Navarez, for what purpose?
Will the gentleman yield
Will
for
the gentleman
question?
yield for questions?
Be happy to
The
yield for
gentleman will
questions.
yield.
Mr. Patty, based on some of the conversations that we had in Sunset regarding this issue, and we had extensive ones, especially around the North Carolina issue and the lawsuit, tell us what we're trying to avoid in terms of what a state agency can do. Right now they're required to submit, or the way I understand it, your bill would require them to submit to the division a review for any proposed rule change, anything regarding the licensing. Is that correct?
Anything related to market competition. So it wouldn't be just any rule. It'd have to be something specific to market competition. And so what we're trying to do here is, number one, eliminate the state being subject to liability for anti-competitive actions, but you also could have the board members that serve and willingly serve in this state on these boards, some 40 boards roughly in the state, they could in fact be subject to personal liability. And so we're trying to remedy that.
Now let me interrupt you right there, Mr. Patty. Would that also, I guess when you're looking at barriers into the entry into the market, would that also be something that the commission would have to consider, or some rulemaking authority that we don't want them to have, I guess is a better question.
Right. Yeah, basically what you would have, you could pick any number of boards that are included here. They're going to have a new rule that they're going to do. That rule, if it relates to market competition, anything that would fall under the umbrella of market competition,
Sure.
It would be sent to this new agency or new department. They would basically give a thumbs up, thumbs down as to whether or not it in any way was anti-competitive or created a necessary barrier to entry for folks seeking to enter the market.
You can correct me if I'm wrong, but I seem to remember a conversation that we had, and I don't remember if it was through a witness or whether it was on the dais, but regarding how burdensome it might be in terms of how many records they'd have to keep and the administrative process of actually being involved in these types of decisions. Do you recall that?
I do.
And could you tell the body exactly how deep the discourse was and how you came to a conclusion when we're looking at a bill like this, because it's got a lot of moving parts?
Yeah, it does. When we look at these boards, many of our boards do have market participants that serve on those boards. And so the question that comes about is, do they have enough of an influence on those boards that they can do things that are anti-competitive? And so we want to make sure that that's not the case. One of the necessary parts is to create active control or active supervision, which is what this new office would do to, again, eliminate that liability both for the state and for the members of these boards.
One of the things that's interesting, too, and I think the body should take note of this, is that we're doing these discussions in Sunset, is that the process would involve picking up a lot of evidence, and most of it, if not all of it, written testimony or written evidence that the body or the agency or the board itself could review when making this decision. And I seem to recall conversations regarding how much information the board would have when we're talking about these market conditions, but I think your bill and you correct me if I'm wrong, does a whole lot in terms of that part of it, making sure there's enough material in front of the body to do it.
Yeah.
Does that make sense?
Yes, absolutely. And I do want to point out that for those that may have some concerns, are we putting in tremendous amount of new power in the office of the governor on this? I don't think that's this at all. I think what happens is they very narrowly are looking at market competition, and they can this new division can either approve the rule, they can reject the proposed rule and return it to the agency with instructions basically that you need to fix this, and that's essentially what they'll do.
Now, and I'll close with this question, Mr. Patty. Is there any issue regarding the appropriation for this, vis-a-vis the governor's office, in terms of how they're going to be able to implement this? Are we going to have any problem with that?
No, it would be accounted for in the budget currently.
All right, thank you.
All right. And I do have a couple of amendments, and if I could, I'd like to offer those up, and then I'd be happy to yield to more questions.
Following amendment, the clerk will read the amendment.
Amendment by Patty.
Chair recognizes Representative Patty to explain the amendment.
Thank you, Mr. Speaker. Members, this is a really short amendment that just adds in two little words here. And basically what we're doing here, this is also a result of some anti-competitive rulemaking that happened as it related to the Texas State Board of Dental Examiners, where we uncovered this. And the effect would have something they were going to do would have driven up cost, effectively prohibiting non-clinical services for dentists, which are things like equipment and furniture and accounting, processing insurance claims, things like that. And so what this amendment does just adds in there that also, if I can get back over to the actual amendment, page 4. So it just says, if it would result in higher prices or reduced competition for a product or service provided by, and then I'm inserting or to a license holder in this state, it's acceptable to the author. I move adoption.
Mr. Patty sends up an amendment. It is acceptable to the author. Is there any objection? Chair hears none. The amendment is adopted. Following amendment, the clerk read the amendment.
Amendment by Patty.
Chair recognizes Representative Patty to explain the amendment.
Thank you, Mr. Speaker. Members, and this amendment's a little more substantive, and let me walk you through this. As we examine this, and we've got three different scenarios here when we're looking at these rules that we have with agencies. You have new rules that might be the result of legislation that we passed this session or any other. Those will be looked at from the lens of market competition to see market competition as it relates to business, occupation, or profession, which the license is for. They will look at that and say, is it anti-competitive, and those type of things. You also have situations because this provision, this bill would also apply to readoption of rules under the Government Code 2001.039, which requires agencies, currently in statute, agencies have to readopt their rules every 4 years. And so they would be subject to that. Those would also go to this new division. So you have a class of rules, if you will, would be those that are up for readoption, that we're considering repealing or readopting with some sort of amendment. So we would want those to be subject to this as well as we examine market competition. Also, you have those that, of course, as they're reviewed every 4 years, all of the rules, that maybe we're not making any changes at all. These are rules that could have been put in any number of years ago. We don't need to modify them. Nothing has happened that would need to modify those. We're going to look at those as well. So what this amendment does, really it speaks to those, because we want this new division over the course of the next 4 years, and I've put an end date of January 1st, 2024, to have the ability to look at all standing rules today and evaluate them again through the lens of market competition and whether or not they're anti-competitive things within those particular rules. But then after January 1st, 2024, we want them just to look at new rules and readoption of rules that are being amended or being proposed to be repealed, not necessarily looking at ones that have been on the books for 20 years. And so we felt like the 4-year window, because of current statute, where they're required to review these every 4 years, that would give them the appropriate amount of time to review existing rules that are in place today and make sure that they don't contain any anti-competitive issues with them. And it's acceptable to the author. I move adoption.
Representative Patty sends up an amendment. It is acceptable to the author. Is there any objection? Chair hears none. The amendment is adopted. Following amendment, the clerk will read the amendment.
Amendment by Schaefer.
Chair recognizes Representative Schaefer to explain his amendment.
Thank you, Mr. Speaker. This amendment will simply add the words price fixing to the definition of anti-market forces.
Chair recognizes Representative Patty to speak against the amendment.
Thank you, Mr. Speaker and members, and I appreciate Mr. Schaefer, and I think I would agree with him, and most of us would, I think, that we would not want price fixing to be going on. However, I would argue, as you look at this bill and you look at the language of this bill, when we're talking more broadly about market competition and the criteria they'll be looking at as it relates to that, that certainly they would take into account a situation that dealt with price fixing. If they were actually trying to make some sort of rule within the agency that would have the effect of being price fixing, there's no doubt in my mind, and I hope it's not in yours, that would be something they would look at and absolutely give a thumbs down on as they relate to whether or not that's anti-competitive. And so for that reason, while I agree that we don't want price fixing, I think that it's already addressed in this current bill, and for that reason I respectfully move to table.
Chair recognizes Representative Schaefer to close.
So, members, let me explain why I think this is important. When you talk about the rules that our agencies put in place for people who have an occupational license, they're going to have an exclusive right from the government to perform that service or to sell that good. And so what we're looking at is not just whether the prices are going to get higher. And you read the bill, the definition talks about higher prices. But you also want to look at a situation where, because of the rule is essentially gives a de facto monopoly to a certain person in a certain geographic area, that results in price fixing. So we don't just want them to look at whether the price is going to go up or not. Competitive pressure often brings prices down. And if in a situation has occurred because of the rule that's made that an occupational license out there has an effective monopoly over a certain way a service is delivered, that results in price fixing. And so all we're asking is for them to do an analysis of that, okay? It's going to be up to their discretion to determine whether price fixing has occurred. And so I think this is a reasonable and good improvement to this bill, which is a good bill, and I want to support. So, members, I would ask you to I would ask you to oppose the motion to table and leave the definition, add price fixing into this, and let the agency take a look at that.
Representative Schaefer sends up an amendment. Mr. Patty moves to table. To division vote. Vote aye with Mr. Patty or nay with Mr. Schaefer. Strike the board. The motion to table fails. Prevails. Sorry, member. The motion to table prevails. Sorry, Mr. Schaefer. Does anyone else wish to speak on for or against Senate Bill 1995? If not, the chair recognizes Representative Patty to close. Mr. Turner, for what purpose?
The gentleman yield for some questions.
The gentleman yield for questions.
Be happy to
the gentleman will yield.
Thank you, Chairman Patty, and thank you for visiting with me about this bill throughout the course of the day and talk through some of the concerns I had earlier. And I just wanted to visit with you about a few things for the purposes of legislative intent, if that's all right. I think we agree, I believe, that it's good public policy to have subject matter experts serve on state licensing boards, that their expertise is invaluable to the missions of those boards. Is that right?
Absolutely. I think the public members are valuable, and also those that are market participants. Obviously, no one knows their business better than them.
Right. But right now, as a result of a Supreme Court case a few years ago, people who agree to serve on these state licensing boards could be sued individually, sued personally. Is that not right?
That is the concern and what we're trying to remedy.
Right. And so my understanding is that this bill, Senate Bill 1995, will attempt to fix that in some response to some recent federal action in the courts I mentioned, and also some model on some actions other states have taken to try to address this issue. Is that right?
Absolutely. I think it addresses the two key points of that. I think it shows that we have a policy in place to prevent this anti-competitive activity, and it shows that we have active control over these boards.
Right. And am I right, and this stems out of a case from North Carolina where a licensing board took action against some folks who were doing teeth whitening, and they were told to cease and desist since they were operating outside the dentist's office. And those individuals sued the state agency and the board members individually, and they won. Basically, that was the genesis of all this.
That's
right?
kind of where it all started, yes, sir.
Right, okay. And the bill is narrowly tailored, right? It creates a third-party review process, but not for all rules, if I understand it right, that a licensing board adopts, only for those related to market competition. Is that correct?
That is absolutely correct. And so if there's something that's outside the bounds of that, that maybe we've debated on this floor, maybe very contentiously, those are not the types of things that could come up. It would be very specific, narrowly tailored to market competition type out.
Okay. And some would say, well, why didn't the legislature just review these types of rules and make these decisions? But that's not really practical, is it?
Well, no, and as you know, and as the body knows, we're just here every other year for 5 months. There are a whole lot of rules being made, mostly as a result of the things that we do in this body, and we're not here to provide oversight for that, and so it's more appropriate to do it this way.
Okay. And so to be perfectly clear, the bill provides a process for active state supervision and a final authority review process to ensure that no conflict of interest could result in an individual serving on a state board and being sued as a result of subsequent litigation. Is that right?
It does provide that protection.
Okay. And it's very similar, I believe, to if you serve on a neighborhood homeowners association board. You're protected, those board members are protected from being sued as individuals. And basically this applies that same logic to our state licensing boards.
Yeah. As I understand it, I think it would be a similar situation.
Well, Representative, thank you for answering my questions on this and addressing some of those concerns. I think this is a good bill that we need to pass, so thank you very much.
All right. Thank you for your support, Mr. Turner.
Mr. Speaker?
Mr. Turner, for what purpose?
I move that the dialogue between Representative Patty and myself be reduced to writing and placed in the Journal for purposes of legislative intent.
Members heard the motion. Is there objection? Chair is none. The motion is adopted.
Mr. Speaker,
Mr. King, for what purpose?
will the gentleman yield
Will the
for some
gentleman yield for
questions?
questions?
Happy to yield
The
to my
gentleman will
chairman.
yield.
Thank you, Mr. Chairman. So it is my understanding that the governor's office, I'm told this, I don't know this is anecdotal, but that the governor's office has been reviewing all of the proposed rules from the agencies for the last 3 years. Do you know if that's true?
Mr. King, if that may or may not be the case, I'm not advised.
Yeah. Well, anecdotally, I'm told that the governor's office involvement in the review of all the proposed rules in the last 3 years has managed to delay the rulemaking processes immensely. So do you anticipate that this new role that you want to give to the governor's office is going to delay the rulemaking process?
Mr. King, I don't, and I would point out again that this is not all. This is ones that are very specific to market competition. And when you look at that, I actually have a list of, although we have many more agencies than this would only affect about 40 boards. Those that have active market participants that serve on those that deal with these types of licenses. And so it would not be every agency, and again, more narrowly, it would not, even with the ones that it does deal with, it would only deal with market competition issues. And so I think it wouldn't be, as we might first think, an unlimited thousands potentially rules. I think it would be a much smaller number.
Well, it's my understanding that this piece of legislation only deals with the agencies where a majority of the board members are made up of people from that particular profession. Is that accurate?
That is the goal, primarily to focus on those. That's correct.
Okay. And so I don't think we're alleging, I mean, it would seem to me that if you're regulating a certain industry, just pick one, that it would be good if you had people on there that were from the industry that understood the day in and day out trials and tribulations of that industry.
Yeah.
Would you not agree?
No, absolutely. I think they provided an invaluable part of that, and nothing will change as it relates to that. And you could have situations where, frankly, even if they weren't, you say it was a 9-member board and there were 5 market participants and 4 public members, I think even if that were reversed and it were or something to the effect of 6 public members and 3 market participants, because those 3 members from the market have such knowledge and probably ultimately deem such respect from those other members because they, hey, you're the expert on that. I think their input is what makes these boards valuable. And so I don't think in any way are we doing anything here that would diminish the value of the expertise of those market participants.
Well, in a typical appointment on a 9-member board will be 6 members from the profession, 2 members from the public, and perhaps 1 member that's an academia or something like that. Is that accurate?
I don't know all the makeups, but I certainly am aware of similar makeups as you just described.
Or maybe 3
they
members
vary.
of the public in some
Yeah,
of them.
sure.
And so it just doesn't seem to me like, and the governor has the right to replace those people every 6 years.
They are
They're
his
typically
appointees.
appointed for 6-year terms.
That's my understanding.
Is that right?
I think generally speaking, that is the case.
No, they're typically appointed for 6-year terms. And so if he feels like that there's something going on nefarious in that particular situation, or if they're doing things that are generating business in one direction or another, he has the opportunity to replace those people every 6 years, doesn't he?
I would agree wholeheartedly with you, Mr. King, but here's the problem. Let's say we have one of those situations and he does try to, as quickly as he can, remedy that. That will not provide any protection for the fact that it happened. Yeah. What is going to determine whether or not there's liability that will exist at the state level and for those board members potentially personally is going to be whether or not we've met kind of 2 levels that we're trying to address in this bill. And first of all, do we have a system in place for monitoring and preventing this anti-competitive type activity? And do we have what's called active supervision, active control, or an oversight of these boards? And that's what we're establishing in the governor's office. And so unless we have those 2 things in place that will in turn provide that protection, even though the governor may remedy it after the fact, that's not going to help the fact that it happened. The state has liability potentially, and the individual members themselves have liability.
Do you have any concern about the whole separation of powers tenet that is in our state constitution between the legislative and the judicial and the executive branch being violated with this type of law?
Sure. And I do understand, and I've had some conversations with members about that. And frankly, myself, that was one of my first concerns when we even started looking at this, is that potentially it was a fairly significant shift in what we do today. But I've gotten comfortable with it, and I'll tell you why. Because there's really 2 things that are going to happen when we submit one of these rules to this division. Is they're going to say thumbs up, we don't see any reason why this is anti-competitive, or thumbs down, we think it is anti-competitive and this is why, and kick it back to that particular board that they could then, they could fix it themselves. And so they're not going to micromanage and say, well, you need to do this or that. They're just going to give you an up or down determination of whether or not they believe it's anti-competitive.
How long do you think that thumbs up or thumbs down process might take?
In the bill, it requires that to happen, and let me grab that for you, Mr. King. I don't want to quote it without looking. Yes, the division shall complete the review no later than the 90th day after the rule is submitted.
Representative Toth raises a point of order. The gentleman's time has expired. The point of order is well taken and sustained.
Move passage.
Question occurs on the passage to 3rd reading of Senate Bill 1995. All those in favor say aye. All those opposed say nay. The ayes have it. Senate Bill 1995 is passed at 3rd reading. Chair lays out, on second reading, Senate Bill 1105. The clerk will read the bill.
SB 1105 by Cole Course relating to administration and operation of Medicaid, including Medicaid managed care.
Chair recognizes Representative Frank to explain the bill.
Members, we currently have 4.1 million people on Medicaid in Texas. This is a big bill, fairly complex bill. It also has a very open caption, so we have about 15 amendments that we're going to be looking at. Medicaid comprises 29% of the current all funds budget, up from 23% just 10 years ago and 19% 20 years. The purpose of this bill is to improve the Medicaid and the managed care. And I do have a perfecting amendment.
Following amendment, clerk read the amendment.
Amendment by Frank.
Chair recognizes Representative Frank to explain the amendment.
Okay, members, this amendment is really to sync with some of the other MCO bills that we did last Friday. It removes duplicative sections that have been reported in previous bills or that conflicted. Move adoption.
Representative Frank sends up an amendment. It is acceptable to the author. Is there any objection? Chair is none. The amendment is adopted. Following amendment, the clerk will read the amendment. Following amendment, the clerk will read the amendment.
Amendment by Raymond.
Chair recognizes Representative Raymond to explain the amendment.
Thank you, Mr. Speaker. Members, this would consolidate each electronic or internet portal operated or maintained by the Commission to Medicaid providers, including nursing facilities participating in the STAR Plus Medicaid program. Move adoption.
Representative Raymond sends up an amendment. It's acceptable to the author. Is there any objection? Chair is none. The amendment is adopted. Following amendment, the clerk will read the amendment.
Amendment by Raymond.
Chair recognizes Representative Raymond to explain the amendment.
Thank you, Mr. Speaker. Members. Sorry. The managed care organization make payment to physician or providers within 30 days. Move adoption. Acceptable to the author.
Representative Raymond sends up an amendment. It is acceptable to the author. Is there any objection? Chair is none. The amendment is adopted. Following amendment, the clerk will read the amendment.
Amendment by Raymond.
Chair recognizes Representative Raymond to explain the amendment.
Thank you, Mr. Speaker. Members, managed care organizations has an ownership interest in a health care provider, and they must make sure that there's a separate provider that does not have ownership. Move passage.
Representative Raymond sends up an amendment. It is acceptable to the author. Is there any objection? Chair is none. The amendment is adopted. Following amendment, clerk will read the amendment.
Amendment by Shaheen.
Chair recognizes Representative Shaheen to explain the amendment.
Thank you, Mr. Speaker. Members, this amendment proposes having HHSC use an independent third party to conduct health assessments for STAR Kids program. Move adoption.
Representative Shaheen sends up an amendment. It's acceptable to the author. Is there any objection? Chair is none. The amendment is adopted. Following amendment, clerk will read the amendment.
Amendment by Cortez.
Chair recognizes Representative Cortez to explain the amendment.
Members, this amendment will streamline the process, improve efficiency, and reduce administrative costs. It's acceptable to the author.
Representative Cortez sends up an amendment. It's acceptable to the author. Any objection? Chair is none. The amendment is adopted. Following amendment, clerk will read the amendment.
Amendment by Ortega.
Chair recognizes Representative Ortega to explain the amendment.
This amendment deals with how to allocate costs associated with community health workers. Move adoption.
Representative Ortega sends up an amendment. It's acceptable to the author. Any objection? Chair is none. The amendment is adopted. Following amendment, clerk will read the amendment.
Amendment by Sheffield.
Chair recognizes Representative Sheffield to explain the amendment.
Thank you, Mr. Speaker. Member, this is to align with the CMS federal coding guidelines. Move passage.
Representative Dr. Sheffield sends up an amendment. It's acceptable to the author. Is there any objection? Chair is none. The amendment is adopted. Following amendment, clerk will read the amendment.
Amendment by Sheffield.
Chair recognizes Representative Sheffield to explain the amendment.
Thank you, Mr. Speaker. Members, this is a national average drug acquisition price. Passed out Public Health 9.0, House 136.7. We're just putting this on to help out the Senate. Move passage.
Representative Sheffield sends up an amendment. It's acceptable to the author. Is there any objection? Chair is none. The amendment is adopted. Following amendment, clerk will read the amendment.
Amendment by Coleman.
Chair recognizes Representative Coleman to explain the amendment.
Thank you, Mr. Speaker. Members, what this amendment does, which is a permissive amendment, it allows us to create a safety net using local government transfers for mental health under the 1115 waiver.
Representative Coleman sends up an amendment. It is acceptable to the author. Any objection? Chair hears none. The amendment is adopted. Following amendment, clerk read the amendment.
Amendment by Alderson.
Chair recognizes Dr. Alverson to explain the amendment.
This amendment simply expands Medicaid providers by simplifying the credentialing process. It's acceptable to the author, and I move adoption.
Dr. Alverson sends up an amendment. It's acceptable to the author. Is there any objection? Chair hears none. The amendment is adopted. Following amendment, clerk read the amendment.
Amendment by Miller.
Chair recognizes Representative Miller to explain the amendment.
Thank you, Mr. Speaker. This allows local health departments to get reimbursed through managed care organizations. It's acceptable to the author.
Representative
Move
Miller
adoption.
sends up an amendment. It's acceptable to the authors. Any objection? Chair hears none. The amendment is adopted. Following amendment, clerk read the amendment.
Amendment by Price.
Chair recognizes Representative Price to explain the amendment.
Thank you, Mr. Speaker. Members, this represents House Bill 1063 that we previously passed. It extends Medicaid telemonitoring reimbursement to pediatric patients. Move passage.
Representative Price sends up an amendment. It's acceptable to the authors. Any objection? Chair hears none. The amendment is adopted. Following amendment, clerk read the amendment.
Amendment by Thompson of Harris.
Chair recognizes Representative Thompson of Harris to explain the amendment.
Mr. Speaker and members, for Coca Day, you can help the people get to $75 monthly for special needs. Move adoption.
Representative Thompson of Harris sends up an amendment. It's acceptable to the author. Any objection? Chair hears none. The amendment is adopted. Following amendment, clerk. Anyone else wish to speak on for or against Senate Bill 1105? If not, the question occurs on passage to third reading. Senate Bill 1105. All those in favor say aye. All those opposed say nay. The ayes have it. Senate Bill 1105 is passed to third reading. Chair recognizes Representative Landgraf for recognition.
Thank you, Mr. Speaker. Members, if I could have the green-clad young folks who are here in the gallery stand up for us, please. You might see a little hardware around their necks. This is the Monahans High School Lobo golf team who just won their second consecutive UIL state golf championship down the road. Let's give them a round of applause.
Chair recognizes Representative Price for a motion.
Thank you, Mr. Speaker. Members, I move to reconsider the vote by which Senate Bill 815 failed to pass.
Members, you heard the motion. Is there objection? Chair is none. The motion is adopted. Chair recognizes Representative Moody for a motion.
Thank you, Mr. Speaker. Members, I move to reconsider the vote by which the third reading amendment number 1 by Moody was adopted.
Members, you heard the motion. Is there objection? Chair is none. The motion is adopted. Chair recognizes Representative Moody.
Withdraw the amendment.
The amendment is withdrawn. Following amendment, the clerk will read the amendment.
Amendment by Moody.
Chair recognizes Representative Moody to explain the amendment.
Members, I want to thank colleagues that were against this earlier that worked with me on something they could potentially support. We have now broadened the language to make sure that breach of the peace is included, any danger to the public is included, any failure to identify is included. All the things you heard on the mics earlier today, they're all included in this amendment, and I move adoption.
Representative Moody sends up an amendment. It's acceptable to the author. Members, Mr. Moody sends up an amendment. It's acceptable to the author. Is there any objection? Chair is none. The amendment is adopted. Does anyone else wish to speak on for or against Senate Bill 815? If not, question occurs. Final passage of Senate Bill 815. Members, as the record vote, the clerk will ring the bell. Shall Representative White voting aye. Here we go again. There being 81 ayes and 52 nays, Senate Bill 815 is finally passed. Finally passed.